So the reason for this webinar is important is because it's part of the private client advisors training and skill to be sensitive to the needs of their clients in order to provide the best advice and service possible. Now, we all have blind spots. We're human. It's natural to have a blind spot, whether it be cultural, ethnicity, gender, anything like that. But today we're focusing on the reoccurring blind spot of a private client advisor, which is the understanding and needs of an LGBTQ plus client. Therefore, this webinar is here to give a good understanding of laws and circumstances which may affect the community. Now, when I say the community throughout this webinar, I am making reference to the LGBTQ community. I may just say the community just for efficiency basis. So for those who prefer not to discuss their sexuality, haven't acclimatized to civil partnerships and same-sex marriage, or face prejudice and discrimination because of their sexual orientation, the law can be a great help. So like I said, we're just going to be focusing on lasting powers of attorney, which is the common abbreviation is LPAs, and wills for today. So moving on to surrogacy and adoption. So we talked briefly about surrogacy and adoption in regards to, there being kind of custody issues and things like that that could arise if you haven't put in the necessary clause in place, guardianship clauses and so forth in place to protect the non-biological parent or to protect the ones who don't have the parental responsibility of that child. So LGBTQ plus parents have a unique set of estate planning concerns when it comes to children, especially when only one partner is the biological parent. Common overseas surrogacy destinations are the USA and Canada, and this is due to the fact that the prospective parents are recognised as the legal parents from birth. But in the UK, the prospective parents are not given the same legal protection, and the surrogate can change their mind at any point until parental order is obtained. So laws surrounding surrogacy overseas in countries such as the USA and Canada are a lot more favourable, are a lot more beneficial than in the UK. In the UK, the prospective parents are not given the same legal protection as abroad, as in the USA and in Canada, and the surrogate can change their mind at any point until parental order is obtained. This is the case even if a surrogacy agreement has been duly signed by all parties, and if the surrogate has already had their expenses paid, they can still change their mind